Be ready. Start. In the Indian criminal jurisprudence, the accused is placed in a somewhat advantageous position than under different jurisprudence of some of the countries in the world. The criminal justice administration system in India places human rights and dignity for human life at a much higher pedestal. In our jurisprudence, an accused is presumed to be innocent till proved guilty. The alleged accused is entitled to fairness and true investigation and fair trial, and the prosecution is expected to play balanced role in the trial of a crime. The investigation should be judicious, fair, transparent, and expeditious to ensure compliance with the basic rule of law. These are the fundamental canons of our criminal jurisprudence, and they are quite in conformity with the constitutional mandate contained in Articles 20 and 21 of the Constitution of India. It is not only the responsibility of the investigating agency but as well as that of the courts to ensure that investigation is fair and does not in any way hamper the freedom of an individual except in accordance with law. Equally enforceable canon of the criminal law is that the high responsibility lies upon the investigating agency not to conduct an investigation in tainted and unfair manner. The investigation should not prima facie be indicative of a biased mind, and every effort should be made to bring the guilty to law, as nobody stands above law, divorce his position and influence in the society. Historically, but consistently, the view of this court has been that an investigation must be fair and effective, must proceed in proper direction in consonance with the ingredients of the offense and not in haphazard manner. In some cases, besides investigation being effective, the accused may have to prove miscarriage of justice, but once it is shown that the accused would be entitled to definite benefit in accordance with law, the investigation should be conducted in a manner so as to draw a just balance between citizens' right under Articles 19 and 21 and expansive power of the police to make investigation. These well established principles have been stated by this court in a number of judgments, wherein it has been stated that a concept of fair investigation and fair trial are concomitant to preservation of the fundamental right of the accused under Article 21 of the Constitution of India. We have referred to this concept of judicious and fair investigation as the right of the accused to fair defense emerges from this concept itself. The accused is not subjected to harassment, his right to defense is not unduly hampered, and what he is entitled to receive in accordance with law is not denied to him contrary to law. In view of the legal principles set out above, if the prosecution case is established by the evidence adduced, then any failure or omission on the part of the investigating officer pales into insignificance when ocular testimony is found credible and cogent and cannot render the case of the prosecution doubtful. If direct evidence is credible, then failure, defect, or negligence in investigation cannot adversely affect the prosecution case. As a general principle, it can be stated that error, illegality, or defect in investigation cannot have any impact unless miscarriage of justice is brought about or serious prejudice is caused to the accused, though the court should be circumspect while evaluating the evidence. Further, it is settled legal proposition that motive is a relevant factor in all criminal cases, whether based on the testimony of eyewitnesses or circumstantial evidence. The question in this regard is whether the prosecution must fail because it failed to prove the motive, or even whether inability to prove motive would weaken the prosecution to any perceptible limit. No doubt, if the prosecution proves the existence of a motive, it would be well and good for it, particularly in a case depending on circumstantial evidence, for such motive could then be counted as one of the circumstances. But when it is a case of direct evidence, even if the absence of motive as alleged is accepted, that is of no consequence when overwhelming evidence are already available on record. It is a settled legal proposition that even if the absence of motive as alleged is accepted, that is of no consequence and pales into insignificance when direct evidence establishes the crime. Therefore, in case there is direct trustworthy evidence of the witness as to commission of an offense, motive loses its significance. Therefore, if the genesis of the motive of the occurrence is not proved, the ocular testimony of the witnesses as to the occurrence could not be discarded only on the ground of absence of motive. If otherwise, the evidence is worthy of reliance. Thank you.